Hey everybody, we're finally going to get into the exceptions of a warrant, of the requirement of a warrant. Okay, a search warrant, an arrest warrant, etc. Okay, I have this small whiteboard here that has the 6 most common exceptions to the requirement of a warrant. Okay, so let's walk through it. As you can see, it's right here. We're going to go through it together. Number 1 is the Payton Doctrine. Number 2 is Exigent Circumstances. Number 3 is searches, incident, lawful arrest. Number 4 is the automobile searches. Number 5 is the consent. And number 6 is the plain view doctrine. Okay? I'll show it to you one more time. Pause the video, write it down, whatever you have to do. Okay? And we're going to go through those 6 right now. Okay? Number 1, the Payton Doctrine. Let's get into it. The definition here is in order to enter an arrestee's home, an officer looking for the arrestee to arrest, the police must have these 2 requirements. Okay, number 1, number 2 on the board. Okay, so in order for an officer to properly enter an arrestee's home to arrest that person, they must, number 1, have an arrest warrant from a judge. Okay, we all know the process of getting a warrant, probable cause, an oath of affirmation, etc. They need this first. Okay, that's requirement number 1. Okay, you need an arrest warrant from a judge. And number 2, which is equally important, is that the officers must have probable cause that the arrestee is in the home. Okay? So they can't just walk into anyone's home and just say, oh, we're looking for James to commit a robbery. The officers can't just walk into the arrestee's home and just say, oh, we think, we have reasonable suspicion that you committed a crime. No, that doesn't cut it. Not only do they need an arrest warrant from a judge, but they also need to go into the arrestee's specific home. And they must have probable cause that he or she is there. Okay? If they have reasonable suspicion, which is a lower standard than probable cause, right? Reasonable suspicion, probable cause, and then way up in the sky is beyond a reasonable doubt. That won't cut it. They need probable cause that the arrestee is in the home. Okay? Furthermore, there's a certain scope that you must understand, because that's really critical for the Payton Doctrine and to this whole scenario here, to the exception of a requirement of a warrant, is that once the officers are inside the home, the police officers can only search for the suspect. Okay? They can only search places where the subject would be. Okay? We all know that, technically speaking, as a human being, we all can crawl underneath the bed and hide under the bed. We can hide in a closet, small closet like this. We'll be all squished in, but it's a hiding spot, right? We all can hide in the attic or the basement, okay? Those are examples of places that an officer can clearly go ahead and look at. There's no problem, okay? But if an officer goes outside of that scope and looks through a bunch of drawers, medicine cabinets, letters, that is outside the scope, and whatever evidence that they may find against the defendant, against the arrestee, that will not be admitted as evidence against the defendant in court. Okay? So, that is the Payton Doctrine. Again, remember this critical requirements here is that there must be an arrest warrant, and there must be probable cause that the arrestee is in the home, and the scope is that once they finally are inside, when check 1 and check 2 are pretty much, once they have these 2 things, right? They can only search for the suspect, right? They can search the bedroom, the closets, okay, the attic, the basement, the bathrooms. That's fine. But they start searching drawers. A human being can't be in a drawer. A human being can't be in a medicine cabinet. A human being cannot be in a letter, right? So they happen to find evidence of a crime. Let's say they find drugs in the medicine cabinet, illegal drugs, cocaine. That will not be used against the defendant because that was an illegal search. Okay, that was outside the scope of the Payton Doctrine. Okay? So now we're going to get into exigent circumstances, and we're also going to get into more case law, because those cases will help us understand exactly what the court holds, what our rule statements are, and exactly what exigent circumstances mean. Okay? So let's finally transition into that right now. Okay, dokie, so let's finally get into exigent circumstances. Exigent circumstances is pretty straightforward. However, it can be a little complicated, which is why we're going to go through the general definition, the things to look out for, and then we'll finally get into some case law. Okay? So let's get into exactly what the definition is and exactly what to look out for when you're thinking about this exception to the requirement of a warrant. Okay? So this states that it must be a fair probability that some interest, the officer trying to basically arrest and search somebody, would be harmed if a warrant is sought. Okay? And the situation with this definition is that, look, it takes time to get a warrant. And sometimes, especially in criminal cases, things can be very dangerous and hostile, and you never know what the fact pattern may be. Therefore, sometimes officers need to act pretty quickly, and they can't just wait around for a warrant, right? So if a warrant is sought, and that interest, right, of trying to do justice and public safety would be harmed, as you can see here, would be harmed, sometimes in certain circumstances, which we're going to talk about, they need to act without the requirement of a warrant from a judge, okay? And the three things that I have here is, number one, destruction or loss of evidence, okay? So let's say that the officers are searching for a drug lord, okay? They happen to find the guy. Let's say that he happens to flush down the drugs in the toilet, right? That is technically destruction or loss of the evidence that the cops need to use against him in order to keep drugs off the streets, right? So that's an example of a situation where an officer can come into someone's home and arrest a person or search for evidence, and if he or she believes that there's going to be destruction or loss of the evidence, okay? Because we know that drugs is pretty small. You have a small plastic baggie, right? So you can simply push it on the toilet and or even eat it, right? Even eat it, and the evidence is lost and the person can be prosecuted, okay? There won't be any evidence against that person, okay? So that's an example. Number two, something to think about, is that hot pursuit, okay? To prevent the subject from eluding escape. To prevent the suspect from eluding escape. And this is probably the most famous thing you see on the show called Cops, right? Campus PD, okay? Where they're chasing someone and it's like a high-speed chase, right? And the guy happens to elude the cops, right? So that's hot pursuit. When an officer's trying to arrest somebody and that person ends up being a threat to society, the officer does not have to have a requirement for a warrant in order to successfully arrest and search that person without a warrant, okay? So again, if that person is let loose in society and, waiting for a warrant is going to take too long, that person could possibly get away, right? That person will elude from escaping from the police officers, right? And cause more harm to other people in the community. Therefore, if a situation like that happens, that's an example of hot pursuit, and that's an example of why a cop can still arrest somebody and search somebody without the requirement of a warrant, okay? So the third thing to look at is that basically it will protect the public or the police officers themselves, okay? And it's kind of sort of related to hot pursuit, where the main objective for police officers is to advance public safety, right? So if they allow someone to elude escape from a crime they just committed, let's say a robbery, the police can't just wait around and wait for a warrant from a judge. They're probably going to arrest that person and search that person without a warrant because they need to protect the public from that person and also themselves from that person, okay? So I have the small whiteboard again, and these are the three questions I want you to keep in mind when we think about this exception to exigent circumstances, okay? So I think you can see it. We have the three questions here. Number one, to think in your mind, is that the showing of probable cause or exigency. So there must be a showing of probable cause that must be shown, and the exigency must be shown. That's what we talked about, hot pursuit, safety for the public, destruction of evidence, okay? That's an exigency. Probable cause, we already talked about that. You need probable cause or an exigency in order to successfully have a exigent circumstance for not having a warrant to arrest somebody and search somebody. Number two is that obtaining a warrant would be impractical. This, how we said earlier, is that if the officers wait around for a warrant, that will take them a long period of time to finally do justice and arrest that person and help the community, etc. Right? Number 3, it must be in the scope. Okay, we talked about this in the Payton Doctrine. Okay, the scope is very critical. Okay, so the search must end. The search must end when immediate action is gone. Okay, what the heck does that mean? I'm just going to show the board to you one more time without my body in the way. Okay, as you can see. Okay, so number 3 is really talking about that once the exigency, let's say, of destruction of evidence is gone, the officers can't continue their search in the home or the search of the person. Once they find what they're looking for, that's it. They can't continue the search on. Okay, so whatever evidence they find after that scenario is not going to be admissible in court. Okay, so let's finally get into the cases, which will help us understand what all this means. Again, it can be a little complicated, right? So let's finally get into the cases so we can finally comprehend what exigent circumstances really mean. All right? All right, so let's finally explain exactly what one of the exigent circumstances really mean. Okay? We are going to get into hot pursuit for this case. Okay? This case is called Hayden, as you can see. And as you can see, I underlined this twice because I want you to pay attention to this fact. It is about hot pursuit and nothing else. Okay? This is the exception to the warrant requirement. Okay? So the facts of the case boils down to these 3 simple sentences, all right? Number 1, Hayden, the defendant, committed a robbery and fled on foot, okay? Basically, he had a gun at him. He pointed it at the cashier, committed a robbery. After he committed the robbery, he fled, okay? That's fact number 1. Fact number 2, 2 witnesses, 2 cab drivers, saw Hayden, the defendant, enter a home, okay? Basically, he fled on foot from the store after he committed a robbery, and he entered a home, okay? Fact number 3, the police officers entered the home that Hayden was in without a warrant. Without a warrant. We all know that in order to go into someone's home, apartment, condo, their castle, they need a search warrant from a judge, right? But in this case, they went inside the home without a warrant. Okay, and they found Hayden upstairs sleeping. Kind of funny, but as he committed the robbery, he fled on foot, went to the home, and he was inside, upstairs in the bed sleeping. Okay, and we all know that with an exigent circumstance, okay, hot pursuit, whatever it may be, that there's a scope. Remember the scope we talked about, okay? They can only enter the home in order to search for Hayden. Okay, so once they apprehend Hayden, they arrest him, take him to the squad car, whatever, that's it. They cannot do anything else. They can't go through someone's papers, they can't look through drawers or medicine cabinets or whatever. If they want to do that, they need a search warrant from a judge, okay? But this story is about hot pursuit only, okay? So they cannot exceed that scope, okay? So once they found Hayden, that's it. They have to leave the home. Okay? And the holding that the court held was that the police officers don't need to have to wait to get a warrant if waiting would endanger the officers' lives and others in the community. Okay? And I think it's pretty fair to say, I don't care who he may be, that if a guy robs a store at gunpoint, he is a threat to society, right? So by all means, the officers have the right to find this guy and arrest him as soon as possible, okay? If they wait for a warrant, he could hurt anyone in society or even hurt an officer who may be looking for him, okay? So that is the reason why the court said that, hey, although they did not have a search warrant to enter the home, that is the exception. That is the exigent circumstance in this situation, okay? And plus, the officers did not exceed the scope of this exigent circumstance because, again, they went into the home to find Hayden. They successfully found him. Thumbs up, arrest him, end the case. Okay? So now we're going to get into another case. And again, we're going to dissect exactly what an exigent circumstance really means because there can be more than one situation than only hot pursuit. Okay? So let's transition into that. Okay, so let's finally go into our last case with exigent circumstances. Okay? We're going to get into Kentucky v. Kane. This is only about destruction or loss of evidence, okay? The officers had probable cause that the person committed the crime, and they feared that if they didn't act quickly enough and if they waited too long for a warrant from a judge, the evidence will be lost or destroyed. Okay? So let's go through these 4 facts here, and we'll go through the holding, and then we'll finally get into the next exception to the requirement of getting a warrant. Okay? So number 1, after King, the defendant, sold drugs as part of a buy and bust, basically they were trying to trick him, say, hey, buy drugs, then we're gonna bust you, right? You know the shows on TV, okay? And after he sold the drugs to the undercover cop, he entered one of 2 apartments, okay? So the officers could not figure out which one he went into. Was it one on the left or the one on the right? Okay? The police didn't know which one he entered, as I said. Fact number 3, the police smelled marijuana. They smelled weed, smelled cannabis, right? And that's what led them to find out which apartment was his because, again, it was a drug and bust. They knew exactly what drugs he sold to the undercover cop because, again, buy and bust, okay? So they smelled marijuana, they smelled weed. They knocked and announced their presence saying, police, open up. And while they said that, they heard people within the apartment complex that they were knocking on, that they were moving things around, right? So the moment they heard people moving in the apartment, moving things around, that is when the police forced her entry within the apartment, searched the apartment, and then they found drugs and seized the drugs, okay? The court held that this was a lawful scenario that did not really need a warrant from a judge to search the home, seize the drugs, and arrest the defendants because there was a not only probable cause that the person committed the crime, but also because there was fear of destruction or loss of evidence that if they waited for a warrant, the evidence of the marijuana would be lost because all you have to do is just put it down the garbage disposal or the toilet to get rid of evidence. And again, they heard people inside moving things inside. Therefore, that's the indication that, hey, King and his buddies inside are trying to get rid of the evidence that we need in order to successfully arrest him. Okay, so because of that reason, that constitutes as an exigent circumstance under the law, and that is an exception to the requirement of a warrant. Okay, so let's finally get into the next exception, the big exception to the warrant requirement, and we'll try our best to understand what's going on here. Okay. All right, so let's finally get into the third exception to the requirement of a warrant, okay? Search incident to a lawful arrest, okay? I like to call search incident to a lawful arrest SILA, S-I-L-A, as a mnemonic that you can use in order to memorize this exception to the warrant requirement, okay? So the definition of this is that the police may conduct a warrantless search if they have probable cause, this is very critical, if they have probable cause that the suspect committed the crime and the suspect, he or she, will be taken into custody, okay? So the 3 rules to keep in mind, which are in blue, they're pretty small, so I'm going to read out loud if you can't see it. These are very critical, so remember these 3 key rules. This is the main thing for this exception to the warrant requirement is that, number 1, the officers can only search the grasping distance of the arrestee. Okay, let's say that you're in a car, you're driving your car. Okay, obviously your grasping distance would really be the passenger seat, right, or the glove department. Okay, or let's say you're reaching your hand in the back seat, you just throw something back there. Okay, that is an example of a grasping distance. Okay. That's the only area that can be searched within this exception, okay? So the officers can't search the entire car, okay? You get pulled over, probable cause, commit a crime, etc. The only area that can be searched under this exception is the grasping area, okay? So example, the cops can't go and open your trunk, okay? That's not a grasping area. You can't reach to your trunk when you're driving your car, right? Therefore, they can't search your trunk, for example. Okay, they can't look under the seat of the passenger side because, again, you can't reach all the way under there, right? Basically, this area is what they can search, right? So that is the grasping distance that this is talking about. Okay, number two is that the officers can only search everything the arrestee is carrying except his or her cell phone. Okay, there is a case that talks about how the officers can't search a cell phone because it's not a reasonable expectation of privacy. That's not important. What's important is that if the arrestee is arrested because they have probable cause that he or she committed a crime, they can basically search the person that they're arresting. Okay, their pockets, they can do a pat down, etc. Okay. Number three, and this is the car example that I talked about, is that the officers can only search of the passenger compartment in a car at the time of the search. Okay, so basically, if you're a passenger of a car, they can search that immediate area. Okay, wherever it's at close proximity to your area. Okay, as I said, a grasping distance from that area. Okay, so these three things are very critical. So just remember, the exception to SILA, search incident to lawful arrest, is that the police officers may conduct a warrantless search if they have probable cause that the suspect committed a crime and he or she will be taken into custody. Okay? So we're finally going to get into two cases that talk directly about this and also the three rules that are in blue. Okay? So let's finally get into those cases right now. Okay, so let's finally get into our first case in regards to SILA, S-I-L-A, search incident to lawful arrest. Okay? We're going to get into Gant, a 2009 case. All right? So fact number one is that Gant, the defendant, was arrested for driving without a license. Okay? He was walking about 10 feet away from his car and he had a warrant out for his arrest because, again, his license was suspended. Okay? Fact number two is that Gant was handcuffed and placed into a patrol car by the officers. And when the police officers searched the car, they found drugs and a gun. So after they handcuffed him, put him in the car, that's when they searched his car, and that's when they found evidence against him for possession of cocaine and also a gun. Okay? However, the court held that this was an unlawful search, and this evidence is basically suppressed because, mainly of fact number two here, I'll read it out loud. The police officers must have the reasonable belief that the evidence is within the arrest, okay? The reasonable belief that the evidence itself, the drugs and the gun in this case, is within the arrest, okay? Think about it. He got arrested because he had his license suspended, okay? Without a license, right? That's why he got arrested. He did not get arrested because the officers had some type of belief that he was in possession of a gun and also some drugs, right? So because it was outside of the scope of the reasonable belief of the evidence connected to the crime itself, that is the reason why the evidence is suppressed, and that's why it is an unlawful search. Okay? So let's finally get into our last case for the exception of search incident to lawful arrest, and we'll get into consent. Let's finally go through our last case in regards to this exception to the requirement of a warrant. Okay? We're going to go to U.S. v. Taylor. U.S. v. Taylor, I compressed this down into three simple facts here, as you can see. Okay? Number one states that the officers went into Taylor's home with an arrest warrant. Okay? He committed the crime, they got an arrest warrant, went into his home to find him. Fact number two, they found him in the attic. So they finally went inside the home, they went up to the attic, and they found him. They handcuffed him and placed him to the patrol car. Fact number three, which is more effective than what we're talking about, is that the officers went back. They went back to the home, to the attic, and then they found a handgun that was at imminent reach within the defendant. Okay? We all know the importance of the imminent reach, right? The grasping distance with this exception, right? However, this evidence was suppressed, and the court stated that the police officers may search grasping distance only at the time of the arrest, okay? So basically, they kind of messed up. The officer should have searched his grasping distance, right, at the time they arrested him when they found him in the attic, okay? But as you can see in fact number 3, they went back to the home, to the attic, and then they found the evidence against him. Okay, big issue, right? It must be at the time, only at the time of the arrest. Okay, anytime after, it's unlawful. It's too late. Okay, so it must be at the time of the arrest when they can search the arrestee's immediate boundaries, right? The grasping distance. Okay, so let's finally get into the exception, the warrant requirement, which is consent. Okay, this one I think is the easiest one out of the 6. Okay, so let's transition to that right now. Okay, so let's finally get into the automobile exception. Okay, on the board I put the auto exception. Auto is short for automobile. Okay, the automobile exception. The police may conduct a warrantless search of a vehicle with PC, with probable cause to search the vehicle. Okay, so as you can see, they need probable cause that a crime has been committed and there's contents of evidence within the car. Okay, that's what they need, probable cause. There's a caveat here though. This is what can be a little tricky with this scenario, is that, look, these two things are critical. Know this, that number one, they can search cars that are in plain view. Okay, for example, you park your car, you're downtown LA, you're going to a big job interview, you park your car, let's say inside the street or within a parking ramp. Okay, let's say you do that. That's open to the public. Okay, that's in plain view as well. Okay, let's say, I don't know, you park your car inside a public street. That's basically what I'm talking about. Okay, as long as it's a public street, that's in plain view. And also, as long as it's open to the public, they can search it. If they pull you over, that's open to the public and your car's in plain view. Okay? However, what's tricky is that if your car is parked in your driveway, your home's driveway, okay, or if you own an apartment on your personal assigned parking, or if your car is simply parked in your open garage, the officers need a warrant in order to search that car. Okay? That's why it's critical to know that it must be in plain view and open to the public. Okay, the reason why they can't search it if it's on your driveway or your assigned parking spot if you live in an apartment is that that's at curtilage to your home. Okay, and we all know the privacy, basically the great standard that the Fourth Amendment has when it comes up to the home. Okay, so because of that reason, there's a very high standard there. Therefore, they do need a warrant in order to search your car if they find it on your driveway or your assigned parking spot or within your garage. Okay? So let's finally get into one case that will help us understand this exception a little better. Okay? So let's get into Acevedo. Okay? It's a 1979 case. So pretty old school case, but it's still relevant to our scenario with the automobile exception to the Fourth Amendment requirement for a warrant. Okay? So, fact number one is that police saw the defendant place a paper bag in the trunk, okay, that they believe have drugs, okay? Only the trunk, not the cab of the vehicle, but the trunk. Keep that in mind. Fact number two, the police officers stopped the defendant, okay, and they searched the trunk, and they find the drugs in the bag, okay? So they had probable cause, the defendant had drugs in the bag, they saw him put it in the trunk, pull him over, they search only the trunk, and then they find the drugs. Okay? So the defendant wants to basically say, no way, you can't just do that, you can't go in my car. However, the court's holding says otherwise. The court says firstly that police officers may search a car and the containers, may search the car and the containers within. Basically, let's say a clear jar you have. Let's say that you have a plastic bottle of, I don't know, Coke, okay? Then you can place stuff within it, right? That's why they have the ability to look through containers as well when they're looking through your car. Assuming that they have probable cause, that a crime and evidence is within the car. Where they believe they have probable cause and there's contraband or other evidence of a crime within, okay? But fact number two is what's really interesting in our case is that, as you can see over here, there's a scope, okay? You see the scope part? There's a scope. And what it says down here that I wrote is that the police officers in this case do not have the right to search the cab of the car. And the reasoning behind why they cannot search the cab of the car, which means they can't search the driver's seat, passenger seat, and the seats in the back, because they had probable cause that he put the paper bag of drugs within the trunk, right? That's why he can only search the trunk of the car, because that's where they believe evidence of a crime, contraband, is within, okay? That's why they had a lawful search here, and they did not need a warrant to use as evidence against the defendant, because again, they have probable cause that they found it within the trunk, okay? And they did. However, if they found drugs also, they found even more drugs or a gun in the cab of the car, let's say the driver's seat, then that evidence would be excluded. Okay, it won't be admissible in the court because they only had probable cause that there was evidence of a crime and contraband within the trunk only. Okay, so they only had the right to search the trunk. Okay, that's why this case is pretty unique, and that's why I chose this for this situation. So let's get into our last exception to the warrant. It's a pretty long video, okay? We're gonna get into the plain view doctrine. Okay, this is pretty straightforward. Okay, so we have one more exception. Okay, we're gonna talk about it, define it, and we're gonna do one case of the plain view doctrine, and then we're gonna wrap it all up. Okay. Alrighty, let's finally get into consent. This is a exception to the warrant requirement. Okay, so let's get into exactly what that means. So the general definition of what consent means is that police may conduct a warrantless search if voluntary, valid consent is given by a person of authority. And if I'm wondering, what does a person of authority mean? Okay, it's not an officer. Okay, a person of authority in this sentence is you, is me. Okay, I'm a person of authority over my own person, of my body. You know, searching me, patting me down, etc. Right? I'm a person of authority over my body. I'm a person of authority over my car. I'm a person of authority over my castle, my apartment, my house. Okay? I'm a person of authority over my backpack. Okay? That's what this means. So the officers may conduct a warrantless search. Basically, they can search your person, your effects, your papers, your houses, if you give voluntary or valid consent to the officer, okay? And you must be a person of authority, okay? Example, let's say the house that has your name on the deed, okay? You are a person of authority, okay? You have a car that's under your name. The title says whatever your name is. You are a person of authority over that effect. Therefore, if you give an officer consent to search that effect, they don't need a warrant, okay? So some things only to look out for is these three things, okay? We have valid consent, police deception, and third-party consent. So I want to explain to you exactly what valid consent means, okay? As we see in our definition, we have voluntary and valid consent. What does that mean? We have to pick apart these words here, okay? So valid consent breaks down into these two simple things, okay? Number one here, we have affirmative indication of consent, okay? Basically saying, yes, officer. Or the officer says, oh, can I search your car? And you do this. That is an affirmative indication of you giving consent to the officer, okay? Or you say, come on in my house. You don't verbally say come in my house, but you do this, give a thumbs up, and you walk into your home with the door open. That is an affirmative indication of consent to the officer to come into your home and search your home, okay? Number two is voluntary consent, okay? What does that mean? That basically means that you're voluntarily allowing the officer to search your papers, effects, etc., right? It must be voluntary. It can't be under duress. It can't be forceful, okay? Sometimes an officer say, I'm coming to your house no matter what. Whether you say yes or no, I'm coming in, okay? And you step aside, let the officer in. That's not actual voluntary consent, okay? That's what that means. That is basically what valid consent really is, okay? We get into police deception, which is probably most popular on the exams, okay? Is that the police officer will have deception of identity, okay? We all know those undercover cops, okay? They look like normal people in society, but they're actually police officers, right? So there are things that you would allow people to do in normal society that you would not allow officers to do, because again, a normal person in society can arrest you, right? They cannot use evidence against you to to bring you into jail, right? But in situations like this, an officer can give you some type of deception because, again, they have cops who are undercover, okay? That's what that means. So therefore, if you, the person of authority, think that you're giving consent to a person who's not a cop, then that's the exception, right? Then they would need a warrant for that. However, if you know that that's a cop in plain clothing and you still get that person consent to search whatever, this exception is not going to cut it, right? This will be whatever they find against you in that search will be lawful. Secondly, we have deception of purpose. Okay, so sometimes there would be a scenario where the officer would tell you, okay, look, I just want to search your backyard, okay? And you get the consent to search your backyard. But then they start rummaging through your shed that's locked, okay? That's an example of deception of purpose. Third-party consent. This is pretty important if you have roommates. Very important if you have roommates. Or you see a fact finder, an essay or MBE that has multiple people who has equal authority in the effect, the houses, etc., right? So third-party consent really boils down to it will be valid consent. Valid consent will be given, okay? If the party, the third person, has common authority over the premises searched, okay? Let's say you live with one of your friends. You and your friend have a 2-bedroom house, okay? Your friend opens the door to an officer and says, oh yeah, come on in. You can search the entire house, come on. That is the person who has common authority over the house because you and your friend both have your names on the lease or the deed, right? You live together, right? Therefore, your roommate, whoever he or she may be, has that common authority over the premises. Therefore, if officers end up going in your room and they find a bag of marijuana or cocaine, they can use that against you because they had consent to search the home because of the third-party person that was involved here that gave them consent to search the home. Okay? So that's what consent really means. Look out for these 3 things, okay? Valid consent, police deception, and third-party consent. And we're going to get into a case that will give us some case law to understand how this can be used in a proper fact pattern, okay? So it's finally transition into a case. Okay, we're going to get into my friend Randolph. Okay, this is focused on consent here, okay? It's very important to understand this case because this has some interesting facts to the exception of the police requiring a warrant. Okay, this is a 2006 case. It's pretty recent in compared to other cases. And I compressed the facts into 4 sentences, so let's finally get into the case. Fact number 1, the officers respond to a domestic dispute call, okay? Basically, Janet, Randolph's significant other, called the cops for domestic abuse, okay? Check 1. Number 2, Janet told the officers that Randolph used cocaine. He was a cocaine user, okay? Fact number 3, police asked him for consent to search the home, and he refuses. Okay, Randolph said, no, you're not searching my home. Well, literally, that's what he said, okay? However, the police asked Janet, the person who resides there, basically the co-tenant, right? As I said, significant other of Randolph, voluntarily gives consent to the officers that come to the home and search it. And guess what they find when they're finally in the home? Fact number 4, the police officers search the home and find drugs. And they use that to incriminate against our buddy Randolph, okay? The holding, the Supreme Court found that this was an unlawful search. And the reason why this is unlawful and the reason why our buddy Randolph is going to get off in regards to them finding drugs in the home is because he's a co-tenant. And he was physically there when the officers were asking for consent. What does that mean? Okay, I wrote it down here. Okay, co-tenants and residents that live within a home, an apartment, a condo, wherever you're living, must be physically present. If they're, let's say at the gas station, and your buddy who lives with you calls you and says, oh, the police is here, man, I'm gonna let them search. And then you who are at the gas station a couple miles down is like, oh no, they can't search my home. That doesn't cut it. okay, the officers can still search the home if your buddy who lives with you as a co-tenant, as a resident in the home, lets them in. Okay, voluntarily gives them consent to come in. Because again, he's a co-tenant and a resident in the home. And furthermore, in order for you to decline the officers to come into the home, you must be physically present. If you're not physically present, like I said, if you're at the gas station and your friend says, oh, the officers are here, they're searching our home, and you're like, what the heck? No, they can't. You can't basically refuse that, because that person who you're living with has the same same authority as you do within the home, because they live with you. Okay, they're the same rights as you do. That's the reason why the police thought that they could search the home, because Janice said, yes, you can search it. But because Randolph was physically present and he told them no, that's why this is unlawful, and that's why this evidence of them finding drugs will not be used against him. And number 2 is kind of small down here, but I'll put kids and parents, okay? So kids don't count, okay? There's a certain hierarchy, okay? When it's parents, mommy and daddy, you and your buddy, or maybe you and a cousin are living together and you guys have your names on the lease, okay? That will suffice. But if your 5-year-old kid is saying, officer, no, you can't search our home, or even your 16-year-old kid who might have some weed in his room says, officer, no, you can't search my room, but your parents say, officer, yes, you can search the house, you can search the room, that's okay, that consent will override the kids' consent, because again, there's a certain hierarchy here, okay? We know who's the man of the house, right? Daddy is, okay? So that's why number 2 is there. Okay, so let's finally get into our other exception, the automobile scenario, and we'll finally understand what these last 2 exceptions to the warrant requirement is all about, okay? Thank you. So last but not least, let's get into the plain view doctrine, okay? So the plain view doctrine means that the police can conduct a seizure of effects in plain view. And again, effects is your backpack, drugs, your car, etc. Those are what effects are. Okay, not your person, not your papers, it's your diary or mail, and not your houses. Okay? Effects. If at the time of the seizure, the police have probable cause, that's the standard, need probable cause, to believe that it is contraband or evidence of a crime, okay? So it must be incriminating evidence, okay? They just can't take whatever they want to, okay? They just can't take your backpack because they feel like it. They just can't take your phone because, oh, I brought up a cause, oh, I'm just gonna take it. No, it must be incriminating in nature. So it must connect to a crime, okay? Contraband, easy. Cocaine is illegal. There we go, okay? You can take it. Probable cause, you seize it, great, there you go, you can seize it. If it's evidence of a crime, if it's a, I don't know, let's say that they see a knife, okay, and it's connected to a crime, then that could be something they can seize as well, okay? So it must be incriminating in nature, okay? So we have requirements here. I wrote down 3 important requirements that we need. As you can see, 1, 2, and 3 down here. Let's go to number 1. So they are, the officers, lawfully in a place when evidence can be plainly viewed. And I know I wrote it pretty small here, but I'm going to read this out loud. So the officers have a warrant. Okay, they have a warrant to search your house. And let's say they have a warrant to search your house to find you, the defendant who committed the crime. Okay, so they can only search the home so they can search where you are, because they have a search warrant to your home, they have a search for your arrest, etc. Right? They can't look in drawers and medicine cabinets for evidence because a human being can't be in those places. Right? We discussed that earlier. Okay? But in number 1's case is that, let's say they have a warrant and they happen to see a bunch of drugs on your tabletop, right? Your kitchen table, a bunch of drugs, a bunch of guns and knives, right? That's incriminating evidence that they can plainly see, and that's evidence that they can seize, okay, against you, okay, if they have a warrant, okay? A second situation where evidence can be plainly viewed if they're lawfully in a place where it can be plainly viewed is the warrant exceptions, okay? Exigent circumstances, consent, okay? And this goes on and on. We talked about the other 5 warrant exceptions that are involved, okay? So the third thing I have here is that they have a non-search view, okay? This is more popular when they pull you over for a traffic ticket and they happen to see a crack pipe right in your your passenger side. Okay, here's your ticket. They happen to look and they see, oh, I see a crack pipe. Sir, get out the car. They could seize that effect and they could use that against you. Okay, or you have an ashtray. Say you have an ashtray and they give you the ticket and they happen to see the ashtray right next to your hand or something like that, because the ashtray is really close by the driver's side, right? It can plainly be seen if you're standing right next to a car, right? So because they're in a non-search view, okay, they're simply giving you a ticket and they happen to see that crack pipe or some cocaine in the ashtray, that is a non-search view. They're lawfully in place when evidence can be plainly viewed, okay? Then that cocaine or that crack pipe in your in that area can be seized, okay? Number two, the evidence is incriminating, immediately apparent, okay? What does that mean? The evidence must be incriminating. Like I talked about, it can't just be your backpack or your new socks you bought from the store, okay? They can't take that. They can't seize that. Doesn't even make sense. Okay, it must be incriminating in nature. We talked about that, okay? It must be immediately apparent, okay? So they can't just stand there for hours thinking like, is that incriminating or not? Maybe? They can't do that. It must be immediately apparent. It must be like, oh my gosh, yeah, duh, dude, that's weed. Duh, that's cocaine. Oh wow, duh, that's a bloody knife. Okay, we gotta take this guy. We gotta seize that, use it as evidence, and take this guy in. Okay, so it must be immediately apparent. Okay, they must know instantly that that's a crime, contraband, or incriminating in nature. Okay. Number three is that what they're doing in the plain view doctrine does not exceed the scope. Okay, so there's a scope here. You can see a trend with these exceptions. There's scopes. Okay, this has a scope as well. So the scope cannot be exceeded of the police search authority. Okay, what does that mean? So let's use the example that I just used of let's say you get pulled over by a cop. Okay, you get pulled over by a cop. You're like, dang it, I went over the speed limit. I know he's gonna give me a ticket. And what's it called? And you happen to have marijuana. You're in a state where marijuana is legal, and you know you have marijuana in your passenger seat, okay? And this cop comes up to you, say, license and registration, please, and they happen to see the marijuana right there. It's obviously there, and that's a situation where they can use that against you. They can seize and use it against you. However, if you happen to have marijuana and you're sneaky, and it's tied up in a plastic bag, and you put cologne all over it and happens to be under the seat, they can't just stand there forever and try to find where it is and look all over your car like this when they're giving you the ticket. They can't do that, okay? That's just an example. Okay, we're gonna go through one case, maybe two, but I think we'll only go through one, where we can talk about the plain view doctrine, okay? I already said a couple examples, so I think you kind of get the point of it, but still, we're gonna go through one last case, and then we're gonna wrap up the exceptions, okay? So let's get into it. The last case is Hicks. This focuses on the plain view doctrine, okay? So let's finally get into this case. This is a 1987 case. A lot of old school cases we're going through, but they're all still relevant, okay? So fact number one, a bullet fired through Hicks's apartment and hit a man, okay? Police officers, fact number two, police officers arrived, entered the apartment, and seized guns, okay? You're probably thinking, what the heck's going on with fact number two? So, because a bullet was shot, he shot below. He shot below, hit somebody, that's an exigent circumstance, okay? Therefore, they were allowed to enter the apartment, and they were able to seize guns and other items because they were in plain view, okay? But that's not the issue for this case. The issue for this case boils down to fact number 3 and 4. Fact number 3 is that while the officer was inside of the home, he suspected that the stereo was stolen. And the officer saw the stereo while he was in the home, and he physically lifted it up, looked underneath the stereo, and saw the serial number, okay? As you can see, fact number 3. While the officer was inside, he suspected the stereo was stolen and lifted. Key word for here is lifted up the stereo to get the serial number, okay? Fact number 4, the police officers then found out that it was stolen property because they matched the serial number to another item which was stolen, okay? So they found in the records, okay, this is a stolen item, so the defendant, Hicks, should be culpable for this crime. Okay, so basically Hicks is taking this to court and say, look, court, this should not be admissible because there was an unlawful search and seizure of my effect, of the stereo. Okay? And the court said, yeah, we agree with you, Hicks, because when the officer lifted up the stereo, by lifting the stereo up, that equaled a brand new search. Okay, we all know that in order to have an actual search, there must be probable cause. Okay, especially the stereo was inside of the home, right? So not only was it unlawful, but it was out of the scope of the original search, okay? Because they went inside the home expecting to find Hicks because they're looking for a criminal who shot that bullet, right? And they saw all the other items lawfully in plain view. That's why they were able to seize the guns and other items. That was completely okay. But the issue here is the fact that because the officer lifted up the stereo, looked at the serial number, and discovered that, hey, this is stolen property, that was a brand new search that was unlawful because, again, he was in the home, no warrant or probable cause that, hey, this person has stolen property within the home, okay? Again, that was a brand new search. The moment he lifted it up and tried to look at the serial number and find out that there was a stolen property, okay? If the stereo, let's say, was facing his direction, let's say that it was not lifted up, but it was basically towards his direction, then that would be fine. But because he had to lift it up, that was a brand new search. Okay? So let's finally wrap up exactly what we're talking about with the exceptions to the warrant requirement on the board, and we can wrap up this video. So finally, we are pretty much done with the warrant exceptions, okay? So let's just go through the 6 that I talked about throughout this whole video. The Payton Doctrine, Exigent Circumstances, like hot pursuit, search and instant lawful arrest. Remember the grasping area, right? Automobile searches. You know, police officers can search your car as long as they have probable cause and it's within a public domain, right? If it's in your garage, in your house, they can't do it, all right? Consent. Must be voluntary consent, okay? If it's not voluntary consent, then no bueno, okay? Lastly, the plain view doctrine. As we know, that the officers must have probable cause, so that's incriminating evidence, okay? As long as they visibly see it and it's pretty clear that that is contraband or incriminating evidence, they can seize it and use it against you, okay? I'm going to put certain timestamps on the comment below or also in the description to show you the times I explain each and every exception, okay? So if you don't like the cases, you can at least see me define each one, all right? Thank you so much for watching, and I'm going to post more about the 4th Amendment and civil procedure, okay?